Welcome to Sipping Legal Tea. So today we have two types of tea and we're going to get into the first. So the first tea is from Jamaica Mountain Peak and it's going to be hot. So the next tea, of course, is the one that comes from CJM. And the question that CJM asked, I'm here to respond. So, CJM, you have asked, what is required when you are in an official common law relationship and you want to separate? Is there something like a divorce? So, thank you, CJM, for that question. So to all my listeners and followers, the answer to this question is that there are no legal documents required. There are no legal documents required for a separation in a common law relationship. So that is one of the main reasons why divorce is held at a higher standard or a higher level than a common law union, because you need a document to get married and that certifies you as being married, and that is of course called your marriage certificate. Now, once there is a breakdown in your relationship from a common law union, you ultimately can go your separate ways without any form of document. Now, the difficulty is that you may have obtained property or properties during the course of this relationship. And of course, the Property Rights of Spouses Act provides that a single man and a single woman who have been living together for a minimum of 5 years, once they have acquired property, they are deemed to be a spouse, and as such, those two parties may be entitled equally to share in that property if they decide to go their separate ways. So there are legal constraints if you are in a common law relationship and decide to separate. However, there is no requirement to separate from that individual or from your spouse, and there is no document needed like a divorce. A decree absolute is the name of that document that you need, or that certifies and verifies your divorce as being finalized. But for a common law relationship, there are no such documents. Thank you. Yes, so we also have another hot piping tea, and it's from MH, who is asking a question. Is there a way you can be divorced if the man who messed up your marriage doesn't want to divorce you and you don't have the money to do so? First, I must say, MH, we have your back. If you need, want, or desire to get a divorce, just call us. We have payment plans just for you. Right, so that's one. Number two, is there a way you can be divorced if the man who messed up your marriage doesn't want to divorce you? For sure. So, one of the myths that we may have in Jamaica is that someone needs to sign, the respondent needs to sign this document, the petition, in order for you to have a divorce. But in Jamaica, we have a no-fault jurisdiction and there's only one ground for divorce, and that is irretrievable breakdown. So, if it is that you desire to get a divorce and the man who you are married to, your husband, doesn't want to divorce you, he doesn't want to sign the document, all you need to do is start the petition. Reach out to an attorney and let the attorney prepare all the documents that is required with the information that you will provide about your marriage. Why is it that this marriage has now come to an end? Right? You must also be able to prove that you have been married for a minimum of 2 years and separated for a minimum of 1 year. Of course, there are exceptions to this. But the general principle is that you're separated for a minimum of 12 months immediately preceding the application for the divorce. Now, once we have prepared that document, simply we stamp it, file it in the court. Once it has been signed off by the registrar of the matrimonial division, then we provide it to you and you will get someone to serve it on your spouse, which is, in your case, your husband. Now, once he is served, he has 2 options. Whether he wants to respond or he doesn't want to respond to the divorce application, the petition. If he doesn't respond, usually within 14 days, then you have all the right to proceed with the second stage of the divorce, and in no time you may be a single person. So, just to keep it short, just to keep it simple, yes, you can be divorced even if your spouse doesn't want to divorce you. Now, the challenge for you is that you will need to be able to fund the divorce process. So call us and let us arrange a payment plan for you, and you can visit our office or call us. Thank you. So, we have another typing T, and it's from CC. So, short the name for your privacy. So, CC, your question is, how can I obtain a will and what's the cost? Alright, so a will is easy to obtain. Alright, but first I must explain to you, this is what you need to do before you try to prepare a will. You must create an inventory of what you own, what you have in your possession that you are the legal owner to. Preferably if you are the sole proprietor, sole owner. That's one column. Column number 2, you want to make sure that you identify all the beneficiaries. That is, all the persons that you want to benefit from your assets. And 3, you want to also identify the proportion that you want to distribute. How it is that you want to distribute your assets. So, say for example, you have a son John. So, son John may be the only child that you have, and you know that you own one house. Now, that's easy. You know that you want to leave your one house to your son John. However, if it is that you have John and Mary, you want with that one house, you want to identify or showcase how it is that John and Mary will own that property. Is it that you are going to leave the property for John and Mary to share as tenants in common or joint tenants? Is it that you want to leave it solely for John and not for Mary? So you must identify specifically what you want to do with your assets and to who you want to leave your asset to and how you want it to be shared. Now, having done all of that, you must ensure that you are the legal owner. So for that same house, you should have your title. And that title should be in your name. The title for that house should be in your name solely, preferably. There are circumstances and exceptions that you can also prepare a will. If you are a joint owner to the property, or if you own the property with someone else as a tenant in common. But it means that your interest is the only portion that you can leave for your beneficiaries if it is held as a tenant in common. Now, once you have prepared all of that, then you must seek the advice and guidance from an attorney who knows how to prepare a will. And of course, identify the executor. So you want to identify an executor, and an executor is essentially a trustworthy person in your life who you feel has good intentions, will act with honesty and integrity to ensure that your wishes are brought to fruition. Now, when you have gone through that process, you would be able to prepare your will, identify and outline who you want to benefit from your asset, how you want them to benefit. And you will sign at the foot or end. And this, of course, is guided by Section 6 of the Wills Act, which outlines the execution, the proper execution of a valid will, which you must sign at the foot or end after you have stated all of the necessary provisions about your assets. After you have signed, which you should sign, or direct someone in your presence to sign on your behalf, there should be 2 witnesses that are there to attest to your signature. So they should be present, or at least they should be shown your signature and should be able to acknowledge that this is your signature, right? So the witnesses will also sign, place their occupation and their address below, and voila, your will would have been created. Some persons go the extra mile and register their will. Now, that is a choice if you wish to do so. It's not mandatory, and your will is created just by putting it in writing. Now, you may desire to register your will, and that means you will stamp it at the stamp office and submit it at the Island Records office. The cost for that is based on the amount of words or characters that is in your will. But the stamp duty fees is $500. Now, the cost to prepare the will varies from attorney to attorney. But I can assure you that if you come to us, we can give you also a nice little package, and our wills usually start at a minimum of $60,000 going up. So, hope to see you, to hear from you, CC. But that's it for now.